Yes, indeed. Taking a look at some of those judgments that were delivered yesterday, and of course, how those reactions continue to, of course, stream in about what transpired previously. We've got Mr. Jibrin Okutakpa, who is a senior advocate of Nigeria, joining us from our studios in Abuja. Good morning, and thank you for joining us today. Well, we know that after the verdict, the ruling of Friday, there was so much expectation. Many were keen to see how will the pendulum swing in different states concerning different cases before the Supreme Court. But having seen how those judgments went, was there anything that particularly stuck out for you in the way the judgments were delivered yesterday?
Well, first of all, let me say good morning to you, Chamberlain in Lagos.
Good morning, thank you.
For me, I was not expecting anything different from what the Supreme Court did yesterday. The Supreme Court has consistently set down some principles which they follow in election petition jurisprudence. And so I was not expecting that the Sokoto judgment will go the way other than the way it went. I didn't expect that the one in Kano will go any other way other than the way it went, because there are certain principles that have been set that the Supreme Court will follow. People became anxious because of what happened in Imo State. And I have consistently told those who care to listen that what happened in Imo State was a peculiar situation that required a peculiar decision. And as a lawyer, my duty under Section 287 of the Constitution is to enforce the obedience of the judgment of the Supreme Court. And so the Supreme Court has decided the decision in Imo State is binding on all authorities and persons, including the political parties against which that decision was given. So I was not surprised that what happened yesterday happened, and it will continue to happen, and heaven will not fall. But let me say this, that we must learn to accept the verdict of our courts and not to desecrate or to say some things that may bring our judicial institution into a total disrepute, because judiciary is the only hope that we have now. Everything in Nigeria with respect appear to have suffered some serious credibility crisis, and we cannot afford to further dampen the credibility of our judicial process. So as a lawyer, and a senior one for that matter, I think it is my duty to defend the institution of the judiciary, because without the judiciary, we will return to the Stone Age, the stone to anarchy, where the mighty becomes right. I have said, and I will want to say here, that until we isolate our judiciary from electoral electoral disputes, politicians will want to win at all costs. And that is why you see that the verdict that have come up so far, for and against, some selected some to protest, others, they are celebrating it. But as lawyer, when you look at the facts of those cases and the facts of cases that have been decided before, you begin to wonder why this protest. But having said that, back to your question, I am not surprised about what happened yesterday. It will continue to happen, and heaven will not fall. And heaven cannot fall, because God, as you know, is a master architect.
When you keep saying heavens will not fall, you sound as if, does anybody want heaven to fall in the first place? People, and the more serious, I mean, when people feel that they don't think justice has been seen to have been done, don't they have a right to protest, albeit peacefully?
Now, let me say that our courts are not subject to public opinion. I think my Lord, Honorable Justice Nikki Toby says so, that public opinion, not all people that are parading on the street and protesting, and incidentally, and let me sympathize with those who had injuries yesterday. You can see what happened yesterday. Some of these protests are not born out of with respect. nationalistic instincts. Some of them are purely partisan to further selfish interest of some partisan politicians. But having said that, let me say that the right to protest is a constitutional right. But when you situate that within the context of Section 287 of our Constitution, can you, other than obeying the Constitution to enforce a judgment of court, protest the judgment of court? Because the Supreme Court is the final court of the land. And they are final, not because they are infallible, because they are human beings. And they have acknowledged so much, even in their judgments, that they can err. But when they err, do you then take to the street to denigrate them? You go back to the court and say, look, you have committed one or two clerical error, one or two mistakes, please correct it. And if you have a cogent and genuine reason within the parameter of how a court, how they can set aside or modify that judgment, they can do so. But to take to the street and do name calling is what I will not support, because to do so will bring these noble men and women into total dispute, and they cannot talk for themselves. The Supreme Court cannot talk for itself. The judiciary cannot talk for itself. Judges are not supposed to go to the press to speak because they are not supposed to be seen to talk. They cannot join issues with anybody on the street. But having said that, let us be careful the way we organize protests about judgments of court, because our courts are courts of procedure. There are processes you need to follow when you go to court.
Well,
and if you don't follow that process, you won't expect to get judgment by emotion and sentiment.
If I could just say this, I mean, when we have some lawyers who have said that, well, the courts, people can get back to the court if, to Supreme Court at that, maybe for clerical errors and typographical, whatever it is. But you also did add now that if certain judgments didn't go in their favor, did you say that they can actually revisit the Supreme Court to ask them to reverse themselves, perhaps if fresh issues come up that were factually or that altered proceedings in a particular scenario? Is that what you're saying?
Yes, Supreme Court had, on a number of occasions, correct itself on when there is obvious clerical error or mistakes on the record. And I have not seen people taken to the street, because if you reasonably believe that the judgment that the Supreme Court had given did not represent the factual situations on the ground, and you have that factual situation that can persuade their lordships to change their position, the civilized way to doing so is to go back to that court and say, my lord, look at A, B, C, and D. If this had been brought to your attention, you can correct yourself, and you have done so before, and you continue to do so when the situation presents itself. But to take to the streets, I have not seen in our Constitution that protesting on the street is another right of appeal from the judgment of the Supreme Court, because the judgment of the Supreme Court is final, and the only place you can appeal to is to come back to them and say, correct yourself, or wait until you get to heaven, when we would have changed our wig and gown to another body, which is a celestial body, other than this kind of corruptible body that we have now. So until we get to that stage, I will advise that we need to be very careful the way we denigrate our judiciary. I am not saying that their lordships are not capable of making mistakes. Indeed, in Adegoke Moto, Adegoke Moto versus Adesanya, the Supreme Court acknowledged that it has capacity to make mistake, and it can make mistake because their lordships are not superhuman beings. They are all human beings capable of making mistakes. But in making that mistakes, we should not attribute ulterior motives to some of these mistakes, because we must build our institution. And
Mr. Okutegba, let me ask you a question based on one of the. Okay, If you just allow me to ask you something a little specific, there's this thing that one of the issues that came up from the Imo election, the governorship election, the Supreme Court's ruling on that election was an issue around the burden of proof. 388 polling units, and the Supreme Court said, you know what, the evidence is just enough. Presentations were made, letters that have been, forms that have been signed, and the Supreme Court said that's okay. But in the case of Bauchi, which was read yesterday by Justice Latijo of the Supreme Court, they said that the appellant alleged infractions in 336 polling units and yet failed to call witnesses in 307 of the said polling units. So it seems like, on the one hand, in the Imo case, the burden of proof documents are just enough. But in this case, the Supreme Court is saying you needed to have brought witnesses physically. Burden of proof, again, on the appellant. How do you react to that?
Thank you, my friend. That's a good question. Now, I have not had the privilege of reading the judgment of Bauchi. Neither have I had the privilege of reading the full reasons for judgments in the Imo State. But I've had the privilege of reading the dissenting judgments of my Lord Honorable Justice F.O. Ohio in the Court of Appeal. And his lordship seems to have made a distinction which appears to have been maybe perhaps the reasons the Supreme Court had come to the conclusion they have come. Now, in Imo State, the case, as I understood it from what I read in the Court of Appeal, was that Senator Hope Uzodimma said that my votes in 388 polling units, which I have the results in my hands, were wrongfully excluded. In that case, the respondent's defense, in which they filed in their petition, from what I read, was that those results were fake. Now, it will be a different thing from what I also understood from the judgments I read of my Lord Justice, the Justice of the Court of Appeal, the dissenting judgments, that we must make a distinction between when you say election did not take place in a polling unit and when you say I have my results from the various polling units, but it was wrongfully excluded. So in that case, his lordship said, no, you don't need to call host of witnesses. All you need to do is to tender the results that was unlawfully excluded. And mark you, and let me say this one, that in our election petition, there are procedures to challenge votes. Under paragraph 12 of the first schedule, if, as Senator Hope Uzodimma was going around with a vote or votes of 388 polling units, and you believed that those votes are not lawful votes, then you must challenge the votes and lead evidence to show why that vote should not be countenanced in election petition. It's not just to say they are fake, because when you allege for a fake, that something is fake, you are talking about forgery, and the burden becomes proof beyond reasonable doubt. So, for me, the decision in Bauchi and the decision in Imo, no two cases are the same. But for the principle of a case to apply, then the facts and circumstances must be the same. So perhaps, given the benefit of doubt and having not read the reason for judgment in the two cases, it will be difficult for me to say the Supreme Court contradicted itself on national television until I read it.
Mr. Okutekpa, one phrase or statement that has recurred over the course of, analyzing the judgment of the Supreme Court is what you just said. I have not read the full judgment. And, a lot of people have said this. So the question for a lot of people is there a time frame as to when the full judgment will be released? I mean, how long do people have to wait? Because a lot of people at this point are waiting and I'm sure you're one of them, to see the full judgment, for some to calm their frayed nerves, for some others to clear some gray areas for them. So is there usually a time frame? How long will we have to wait, perhaps?
Now, Kayode, I think Nigerians must also be made to understand that the Supreme Court, as presently constituted, I'm not too sure there are more than 14 justices of that court handling election petitions involving, apart from Jigawa State, where there was no election petition. I think it appears to me that there are petitions from across the 36 states of the Federation. And all these appeals, including the presidential appeal, went to the Supreme Court. And their lordships have 60 days within which to deliver judgments. So let's be patient. We will see it when it is ready. We will read it. We will criticize it. And their lordship will look at our criticism. And perhaps if our criticisms are borne out genuinely, devoid of partisanship, devoid of emotion, they may look at it in subsequent cases and then take corrections. But until we see it, it will be premature to begin to criticize them when you have not seen the reasons for the decision.
What I'm trying to say is there a time frame? I mean, you mentioned, 60 days earlier. So usually we have time frames for things such as this. So for this particular one, is there a time frame?
The Constitution allowed them to deliver their judgment and give reasons later. So I have not found where it is specified in the Constitution the number of days that they're supposed to give the reason for decision. But the Constitution allowed them to deliver bench judgment, bench ruling, or give instant decision and give their reason later. And they have been doing so. This is not the first time that they have done so. Even if in presidential election, they have done so, and they did it so in the Atiku's case. They gave their reasons later. So this is not the first time. And this judgment was just delivered last week for Imo. This one of Bauchi just yesterday. And as I talk with you today, they are still sitting on election petition, appeals for governorship. So until they conclude the hearing and of this appeal, which are time-bound, I don't think you will stampede them to give you dates for which they can give their reasons.
Right. Now, earlier on, I want to refer to something you mentioned, which was quite instructive. You said it's perhaps time to insulate the judiciary from proceedings such as this that might eventually now bring in political coloration that we have seen, from the protests and the analysis. So I'd like to ask you, if you say we should insulate the judiciary, in what way would you propose?
I think time has come for us to have a constitutional court that handles election petition matters. But before I advocate this constitutional court, I think there is a need for us to speak to Nigerian politicians. Because if we respect our electoral laws, our constitution, and the politicians are patriotic and nationalistic enough, and they have not this propensity to win at all costs, even when they are not popular. You are witnesses to what appears to be gunshot democracy, democracy that is, people are now being shot, thugs have a few days, everything is left for political thuggery to print ballot papers, cut ballot papers away for their principals. We are all witnesses to this. And why? It's because our politics has become do or die. Nobody has respect for the sovereignty of the people. The people's view do not seem to matter. Our politicians want to win at all costs. So as long as politicians want to win at all costs, and they have no respect for our Constitution, the rule of law, the Electoral Act. So we'll continue to witness this kind of hulabaloo in our election matters. So for me, if we want our judiciary to continue to adjudicate over electoral process, then we must change some of our principles of law. For instance, the principles of law that says if you have a certified true copy of a public document, you must still call the maker, needs to be looked into, because you are all aware that these politicians have mastered the strategies that even witnesses that witness electoral fraud are afraid to come out because they can be set ablaze even in their sleep. You're also aware of some of the principles of law of dumping. Nigerian courts is a court that conducts, or a court that conducts proceedings in English language. Documents of INEC are written in English language. What am I then need to demonstrate other than to tender the document and show the court that if you look at this voters register, for instance, it was not unprinted? Should I call somebody who didn't unprint the voters register to come and say, I did not unprint, or that it was not marked? Must I call the presiding officer who did not mark it to come and say, I did not mark it, when you can see it, that it was not marked? We must also appreciate some of the introduction to curb electoral fraud by INEC, that is the smart card reader. The role of smart card reader must be legalized. The way we throw away smart card readers' report vis-a-vis the manual accreditation is creating room for electoral fraud. And we must do something about it if we want free, fair, and credible election in this country. And our court must be court of policy, not of court that is legalistic, and people come to court to look for justice, then you discharge judgment that may not contain justice in it. So I think that we can isolate our judiciary from partisan cases by creating a special court.
We'll let you shed some more light on some of those issues that you've highlighted when we return in just a moment. Stay with us. Welcome back to Sunrise Daily. Now, you were talking about certification of certain documents and how you like to see certain changes such that it could be a lot easier. But if you could you give us your impression about this? I mean, referring to the case with Imo now, there are those who believe that, for instance, when the police officer was subpoenaed to come to the court and then testify, speak on some of those results, those who wonder, how is it that INEC in the first instance weren't subpoenaed? Because could the police certify a document that they didn't author? Because INEC authored that document. Shouldn't they be the ones to certify whether or not it was theirs?
You see, let me say this, that laws are not, our laws are not based on emotion of people. Under Section 63 of the Electoral Act, there is a provision there that when election is conducted, INEC should give duplicate copies of results to party agents, security agents that are available at that material time. And that inbuilt system was put there by our lawmaker to prevent conspiracy that may happen, for instance, between INEC withholding results, which it has in its custody and refused to produce, and a candidate saying that, look, like, let's take the case of Senator Hope Uzodinma, for instance. He said, look, I have my votes in 388 polling units, and you, this INEC, you did not include these votes before you gave me 92,000 or so votes. Add to it before you make declaration. And there was an argument between them that that vote is fake, this one is not correct, this is authentic, this is not authentic. Now, the lawyer took a step under the Electoral Act to subpoena the security agent that had copies of this result and say, produce it and tender it for me because I have copy of it. And authorities are bound in our law reports that where there is a dispute as to whether or not the result in a particular polling unit is authentic or not, the result given to security agents comes in handy to resolve that dispute because it is presumed that these security agents are neutral, they will not be partisan, they will not be bought over. As to whether or not that presumption is correct is debatable within Nigerian soil. As to whether or not even INEC is an independent electoral commission, as indeed, in fact, is also debatable in this country. Because in Nigeria, you know that everything is possible. It is possible to have a degree without attending university and hold the result in your hands. So that is why I am of the humble view that these presumptions of regularities of INEC results, time has come for us to do away with it. Because you presume something regular in an environment where people have the national and nationalistic instinct to owe allegiance to institutions, owe allegiance to the Federal Republic of Nigeria, not owing allegiance to either the one who has the means of production, which is called money, or the one that is in power. Because you will agree with me, and most Nigerians appreciate this, that most of us in public institutions do not owe allegiance to the Constitution of the Federal Republic of Nigeria or the oath of office we took. We owe allegiance in most cases to he who dictates the pipe or the one who has the money in his pocket. So, I've advocated in the brief I wrote, and I have said it, and I'm saying it, that time had come for us to interrogate the presumption of regularities of INEC results. Until we do so and make INEC to come and prove that indeed it conducted the election in a free, fair, and credible manner, we will not go anywhere. Because today, all you need to do to remain in power is to force INEC to announce the result. And then the law will presume that the result announced by INEC is genuine. When indeed, even the deaf, the blind can see that some of these results are not genuine, but they are presumed genuine, and the court is not a Father Christmas. You will follow the law because they swore to interpret and apply the law. So for me, rather than blaming the judiciary, blaming the Supreme Court,
if I could put this in, what I did ask was,
who signed,
just a moment, what I did say
who
is,
wrote the result.
it's not on the tendering of the
Supreme Court
results.
did not write the result.
Yeah, but it's not about just tendering the results. I'm talking about certification of those results. That's the point I'm making. So
you don't need to certify. Chamberlain, in 30 versus Ukpabi, the Supreme Court said the counterpart copy made through the same mechanical processes constitute original copy of the result. You need certification when you want a photostat copy of a copy that is with the police or a copy that is with INEC. You don't need certification of a duplicate copy of result given to party agents, security agents, or even the observers, if there is anything like that. So we don't need certification of copies of results that are being given to security agents from polling units. Once the security agents have copies of the result, the pink color in the polling unit,
how do you ascertain that it's a genuine copy indeed? I think that's the question here now. How do you ascertain that the copy with the security agents, whether certified or not, is a true copy indeed and represents, you know, the true position that the law is trying to validate?
First, you must note that all ballot papers have serial number. did INEC seriously contend that the duplicate copies of the results that Senator Hope Uzodinma tendered had no equivalent serial number with the copies of the result they had, or what is called ballot paper distribution form? Every ballot papers that are distributed to polling units have a serial number attached to it. Was it seriously disputed and challenged in a serious manner that indeed the serial number of the polling unit results tendered before the trial tribunal and admitted, which was in any case challenged at address stage, was not indeed a copy of document emanating from INEC? These are a series of questions that you need to interrogate INEC and officials who conducted the election. Because if indeed we are serious and want democracy to grow, then the politicians should allow democracy to grow. It is not the court that is the cause of democracy not growing. It's the politicians.
All right, speak to this one issue.
I must win at all costs.
All right, speak to this one issue before we go. The judgment delivered by Justice Kekereekun on behalf of the members of the panel of the Supreme Court did say that the lower courts, the tribunal and the Court of Appeal, misconstrued the prayer of Senator Hope Uzodinma, that he wasn't contesting the validity of the election, but that his votes were excluded. How come the lower courts missed that, and it was only at the Supreme Court that was found out?
Carol, that is why we have hierarchy of court. Because the case of Senator Hope Uzodinma was not that election did not take place in all the 388 polling units. His case, it was simple, straightforward, unambiguous, and it was this, that I have this number of votes from these polling units, and it is the responsibility of INEC to add it before it makes a return. INEC did not make a return. Now, at the trial tribunal was, authorities were cited before the trial tribunal to say, look, if you say election took place in this place, in this place, in this place, you must call persons from each of the polling units to validate the result of the election. And the lordship made a distinction that no, the case is not that election did not take place. The case is that you unlawfully excluded my vote, and that the trial tribunal misconstrued the case. And in any case, let me say this. This is not the first time that the Supreme Court have to overturn the judgments of trial tribunal and the Court of Appeal and give a different judgment at the Supreme Court that represent the law. First, in Umana against Udom, the Supreme Court changed the judgment, overturned the judgment of the trial tribunal at the Court of Appeal. The same thing with His Excellency, the governor of Rivers State. He had his election nullified at the trial tribunal, had it affirmed at the Court of Appeal. The Supreme Court said no, that they follow wrong process to arrive at that decision. So this is not the first time. And like I said in the beginning, Supreme Court will remain Supreme Court, and it will deliver judgments. Heaven will not fall, and heaven cannot fall.
Just one more thing as we wind down. Just one more thing as we wind down on this one. And correct me if I'm wrong. I thought that in Totti versus Ukwabi, the court laid down the principle of proper custody, holding that it is the body that authors a document that can certify it. Is that right?
No. Totti versus Ukwabi decided so many principles of law, one of which is that a duplicate copies of results issued to party agents constitute original. It does not require certification. So that's the authority, that's the principle, and it has been principles of law of considerable antiquity that we have been applying to our election petition jurisprudence. It has not changed. It may not change until we are able to show the Supreme Court that indeed it's working in justice, and Supreme Court will look at it. And like I said, and I want to say here, that time has come to lessen the burden of losers of elections in Nigeria, knowing the way and manner our politicians force themselves on us and meander their ways to power by hook or crook means, not in accordance with the electoral process. Time has come that we should be able to interrogate some of these election cases. I expect politicians to take to the street when they outmaneuver themselves, not when documents are produced, the court apply the law, because a court of law is not supposed to engage in partisanship. If they do, they would certainly lose their neutrality and the impartiality expected of an adjudicating authority. So
right, then
it is the case before the court, applying the law, not sentiment, not emotion, not I must win at all costs mentality. And in any case, in any race, well, a winner must emerge. If you go to court, that is the outcome.
There are so many questions that will be answered. Perhaps when the full judgment is released by the court. I mean, people want to know how those votes, whether or not they tally with the total number of votes and votes cast, beyond the fact that votes were excluded, eventually added and by the court, and then the winner was announced. They will look at spread eventually. Did they meet the spread? So many questions, but
and you also know, Chamberlain, that the issue of spread is a constitutional matter. Those people carrying placard, do they meet a constitutional spread?
All right, we'll wait until the full judgment is out, and then we'll take it from there. But we thank you for coming on this morning, Mr. Jibrin Okutagba, Senior Advocate of Nigeria.